Thank you, Madam.
Yo, it's Big. Hold on just a second, y'all. Hold on. We are right now inside the courtroom, YSL. Well, hold on, my bad. Yo, it's Big Ant, the spokesman, man. We back. Another edition of Urban Politicians TV, UPTV. Make sure you stay on your pivot at all times, man. Had to come tap in real quick. Young Thug, Gunna are in court. This is coming from 11 Live YouTube channel. Make sure y'all gonna tap in with them. We're gonna talk about it, commentate about it, and everything like that. Been covering this since it started, but they are in court this morning. I heard from before I went live, they were going to be talking about the new indictments, and this is a motion hearing and everything like that. They're talking about their behavior. The prosecutor, that white guy we've been seeing, is talking about what's been going on with them behind the wall and everything like that, man. So he been pointing that out. We're going to listen to it and go down through there. We'll get feedback, comments, all that. But he is really sticking it to them on the side of things that he said they trying to smuggle cell phones in. He said they've been trying to smuggle this in, that in, and everything of that nature. But this is coming from the 11 Live directly inside the courtroom, man. So we got more coming. I'm actually going to be doing other things too at the same time this is going on. But we're going to watch it. We're going to talk about it, man. Tell me if it's too loud. Right now, they are in Cobb County Court, if I'm not mistaken. They addressed Gunna not too long ago in there. When they take a break, we'll go rewind and tap in some more.
I am aware of that other case. It is a 10 SC case. I believe it's 10 SC. Nine 2020. So I will just put it.
Can y'all hear?
You wish to go ahead and deal with that particular case? Can I? Ms. Mormon, would you like to waive arraignment on both those two cases, the 10 SC case as well as the indictment then under the new case, which is the 22 SC 573. 22 SC 183572.
Kind of low.
That's the new case, correct?
182,573. Tell me if it's too loud because it was super loud. I know I'm loud as hell.
The counter has.
Is that too loud? Let me know something.
See, the clerk is written on the.
Too loud?
The 22 SC 183572.
I can only know if y'all tell me. It's perfect.
That's the re-indicted case. Okay, all right.
Okay, so the 10th case is the motion for new trial that Judge Newkirk granted. So the question for me is, do you want me to keep this case along with that case to deal with it, or put that to the side? What would you like with the 10th case?
Set the trial,
yeah, we'll just put it in a trial posture, and put it on a trial calendar. In fact, it can go on that 9.
Because we need to keep account for the 10.
I'll put it on the 9 January 2023 calendar, madam, and I'll probably, unless we got, and more than likely I will move it.
Hold on real quick, y'all. Hold on real quick.
Trial dates come later this fall, okay? But just for accountability purposes, I'll continue. I'll go ahead and just lump that case with it. But as for the new indictment ending in 572, would you like to otherwise waive formal arraignment, have the court enter a not guilty plea on behalf of your client, otherwise have at least 30 days from the receipt of discovery to file any motions now? Okay, all right. I'm going to go ahead and put it on that 9/23, January 9th, 2023 calendar, okay? And and I'll also track the 10 SC 2020 case, but, for the 10 SC 92020 case, we'll put that on another calendar, okay? All right, thank you. All right. Mr. Greer, you can be excused at this point in time. Your attorney, Ms. Mormons, will talk with you a little bit later on, okay? Okay, oh, we have a waiver issue with him? Okay. All right. You want to go ahead and take that up now?
Yes.
Okay, all right. All right.
Make an additional inquiry, please.
You can.
You mentioned earlier and asking that prepared in order. That's the opportunity to denying the base motion to remove Mr. Steele as attorney for Mr. Williams. Both there are four individuals who are mentioned in the conflict, and we addressed one, we're about to address the second one, and the other one will not be addressed until at least the 8th. I would court overall, I'm drafting that order. That's all.
No. Go ahead and do the order.
Y'all can hear, y'all can hear.
I'll enter supplemental order when those two folks are taken up, okay?
Yes, sir. May I say something else?
You can.
Earlier, before I made reference to, I thought that.
Hey, y'all, let me know if y'all can hear. Is the audio good? I know it's kind of like, because it's coming through this other thing. Shout out to 11 Alive on their YouTube channel. They the one, streaming this motherfucker and everything. But, they the little court, I guess, like the news station. But for people that's coming in, this is like a motion hearing, and they're going to be discussing the new indictments that they also received over the guns that was at the house, the drugs and everything like that. They already had talked to Gunna, and Thug is in the courtroom also right now. I think that's him in that top right-hand corner, but we'll talk in a little bit. Let me know what the audio like, though.
And consider everything that you tell me and any motions that you file. But what you do is when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But having said that, I do get to control the method and manner of how things go in the courtroom.
I know this is your court, but
there's some smoke. There's some smoke.
And I just feel like the court telling me to sit down or what I can do is take my seat was not appropriate. I treat the court always with deference, with respect. The only thing that I ask is that the court treat me the same way.
I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility. Okay? Anything else, sir?
It's getting real, nigga.
Okay, who do we have at this point in time? Okay. Let me see if I can get Mr. Gridley. Okay. Let me mark that as the next court exhibit in order. I want to say it's court 3. Is that correct, Ms. Williams? Okay, all right. Okay, Mr. Greer, can I get, I should say, Ms. Amana, can you go ahead and unmute, Mr. Greer, please? And the reason I'm muting him again, count folks, is because there's a lot of background noise in the jail. So, yes.
This the real process right here, man. This how it really go. This will really be happening when you go down through there, bro. Like, This is the part that that a lot of people don't get to see, you know, with the music, the internet.
Okay, I think he's unmuted now. Mr. Greer, again, good afternoon, sir. Sir, I'm holding at this point, let me go ahead and swear you in at this point in time. Can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm? Yes, Your Honor. I'll put your hand down. Okay, all right. Sir, I'm in possession of a waiver for you. It's addressed from the law office of Lawrence J. Zimmerman, PC, and I believe it was dated or authored on the 20th of May of 2022. All right, did you have an opportunity to to read that particular document? Yes, Your Honor. Or before Mr. Zimmerman penned it, for you to discuss the things that we'll cover in regards to conflict? Yes, Your Honor. Okay, I'm going to read it because it's very short. It just says, Dear Brian, I've met with my client, Quantavious Greer, regarding any potential conflicts of interest. He met with you, is that correct? Yes, Your Honor. That he being Mr. Zimmerman, right? Yes, Your Honor. All right. And he advised you of all the issues regarding your prior representation of him and your current representation of Mr. Jeffrey Williams. Is that correct? Yes, Your Honor. And then you discussed with Mr. Zimmerman all the issues regarding potential conflicts in this matter. Is that correct? Yes, Your Honor. Is that right? Yes, Your Honor. Okay, and that you are he is insistent that you represent Mr. Williams, and he waives any conflicts of interest. Is that correct? Yes, Your Honor. And that it further says, I advise him that the court may ask him questions about these issues on the record. Is that correct? Yes, Your Honor. Did he tell you that? Yes, Your Honor. Let me just kind of ask you a couple other additional questions, okay? Because this is I just want to make sure that you understand what you're waiving at this point in time. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other? Yes, Your Honor. Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other? So it could be helpful to somebody else and be harmful against you. Do you understand that? Yes, Your Honor. Also, do you understand that the lawyer may want to use a defense theory, witness evidence, or argument that's helpful to the lawyer's current client? That would be Mr. Williams, and harmful to you. You understand that? Yes, sir. During closing argument, the lawyer may want to argue the evidence against his current client is less than the evidence against the former client. You understand that? I understand, Your Honor. All right. You also understand that if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client. Yes.
Basically, reading them all the stuff off, he got to agree to it because of they having the same lawyer and things like that, and how it could affect his case. And they got to make sure that he's okay with it and that he understand what he up against by having the same lawyer. As I'm thinking, if I got to correct Young Thug, that him and Young Thug gonna have the same lawyer, and he's trying to make sure he understands what could possibly happen and how it could affect his situation.
Nobody's forced or threatened or tricked you into doing so.
Yes, Your Honor.
Have you had an opportunity to speak to fully consider this waiver?
Yes, Your Honor.
And any potential conflicts of interest?
Yes, Your Honor.
All right. Any further inquiry you want to make, Mr. Adams?
No.
All right. What about you, Mr. Gibb, or Ms. Rosenwasser? Okay, and I've admitted that is number 3. The letter from Mr. Zimmerman as Court Exhibit 3. Okay, anything else? Mr. Adams? No, sir. Okay, all right. Can we go ahead and arraign Mr. Williams on the new charge or the new indictment?
Yes, sir.
Okay, all right. You want to go ahead and waive formal arraignment, otherwise have the court enter a not guilty plea and otherwise have at least 30 days to file any motions on under the new indictment.
These are the new
22
charges.
SC 183572, sir.
Your Honor, we waive formal arraignment, we do enter a plea of not guilty on the new indictment. We do ask for the court had granted us previously. Previously, the court had given us 60 days from the receipt of all discovery to file particularizing motions. We ask for that this time.
I'll give you 30 days, and then the only reason why is because you all have started the discovery process. I don't know whether or not. I suspect you've probably gotten some discovery, but I'm flexible with that. But let's go with 30 for the time being, okay? Okay. Yes, sir.
So they plead not guilty to the new
And
indictment.
include those. I believe that Mr. Geary owes an order in that respect, and we can incorporate that by reference, okay?
Thank you.
Okay, are there any other waivers that I need Mr. Adams, I need to take up in regards to Mr. Steele that are here today? I don't know if there are any, because.
Yes, Your Honor.
Yeah, Ed Adams is on, and as well as Ms. Merchant, and I think that they have, Martinez Arnold. Let me see if he's on. Is Mr. Arnold, are you on? Martinez Arnold?
This is Duke, y'all. This is Lil Duke or Duke.
Are you Mr. Arnold?
Yes, Your Honor.
Okay.
YSL
He
Duke.
is there. All right. Okay. All right. Let me see if I have his waiver. Ms. Merton and Mr. Adams, thank you for your patience with us today. I'm going to mark this one as court exhibit next in order, and that would be, I think, court's 4.
For people just coming in, this is
Mr.
Duke.
Arnold, where are you, sir? Can I get you to raise your right hand for me, sir, if you wouldn't mind? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm? I can put your hand down. Okay, all right. Mr. Arnold, just want to go through a couple things with you to begin with. Are you aware that Mr. Adams, on your behalf, penned, that is authored a letter to Mr. Steele on the 19th of May, 2020?
Yes.
All right, are you familiar with the contents of that letter, sir?
Yes, Your Honor.
In terms of the waiver?
Yes.
Okay, I'm just gonna go through it with you again, because it's 4 paragraphs, and I'll just read it and ask you some questions as we go along, okay? Is that all right?
Yes, Your Honor.
Okay, all right. It says, "Dear Brian, I am authorized to make statements herein on behalf of my client, Martinez Arnold. I represented Mr. Arnold in the state of Georgia versus Martinez Arnold, indictment 14 SC 131032, Fulton County Superior Court, which is a case involving a shooting at Lenox Mall." Is that the indictment that is referenced that he spoke with you about?
Yes, Your Honor.
Okay, all right. Mr. Arnold pled guilty to reckless conduct on or about February 18, 2015. That's correct?
Yes, Your Honor.
All right. I am aware of the state's motion to disqualify you, and that would be Mr. Steele, as counsel for Mr. Jeffrey Williams in the state of Georgia versus Mr. Jeffrey Williams et al. And that was under indictment 22 SC 182273. And that was the indictment at that point in time. Do you understand that?
Yes, Your Honor.
Do you understand the case has been re-indicted under 22 SC 183572? You understand that, right?
Yes, Your Honor.
Okay, all right. All right, and that,
So the case that he caught in 2015 is being brought back up now for people who don't understand. He had the other case that he had caught in 2015. They are re-indicting that, basically just making it part of this Rico charge, which ties him to YSL because of the case that happened in 2015, which is this how the system works. The shit be fucked up. If I got it correctly, that's exactly what they just did.
And that is the matter in which Mr. Arnold, that would be you as a co-defendant. You understand that?
Yes, Your Honor.
Okay, you have to speak up so I can hear you, okay?
Yes, Your Honor.
Okay, all right, thank you. The motion to disqualify is based in part on the allegation that you represented Mr. Arnold on matters relating to the 14 SC 131032 case. That's your understanding, correct?
Yes, Your
And
Honor.
Mr. Steele representing you in that case, and he's representing Mr. Williams in this matter. You understand that?
Yes, Your Honor.
Okay, all right. I spoke with Mr. Martinez Arnold. This is Mr. Adams, okay? Regarding the state's motion to disqualify you as counsel. I explained to him what the state alleged with regard to you, specifically you, that Brian Steele represented Mr. Arnold on matters relating to the indictment we just mentioned, 14 SC 131032. I further explained to Mr. Arnold, that was you, the relevant law and ethical concerns at issue, and specifically that you're entitled to conflict-free counsel, and that you are representing Mr. Williams in this indictment, 22 SC 182273, which is now indictment 22 SC 183572, in which you are a co-defendant. You understand that, right?
Yes, Your Honor.
Okay. And he explained to you that you can object to Mr. Steele representing Mr. Williams.
Yes, Your Honor.
Okay, all right. And after providing the explanations that we just kind of went through, did you make it clear and unequivocal to Mr. Arnold that Mr. Adams, that you were never represented him relating to any shooting at Lenox Mall or any other matter?
Yes, Your Honor.
Okay, basically what Mr. Adams is saying is that Mr. Steele didn't represent you in any shooting at Lenox Mall. Is that what you understood?
Correct.
Okay, all right. Or any other matter, correct?
That's correct.
Okay, all right, and then you explained that he believes that his friends contacted Mr. Steele shortly after the shooting to inquire whether there was an outstanding warrant for you. Is that correct? Say again?
That's correct, Your Honor.
Okay, and you insist that you never spoke with Mr. Steele about the case or any of the facts and the surrounding circumstances, correct?
That's correct. Correct, Your Honor.
All right. Let me ask you a couple of additional questions, just to make sure. Do you understand that the state could offer to dismiss the case against one of the co-defendants, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, Your Honor.
That the lawyer may wish to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client.
Yes, Your Honor.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client.
Yes, Your Honor.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
And a lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes, Your Honor.
Do you intelligently, knowingly, and voluntarily waive any potential conflict of interest that would stem from any involvement you had with Mr. Steele and or indictment 14 SC 131032?
Yes, Your Honor.
All right. And you don't have any issue with Mr. Steele representing Mr. Williams?
Not at all, Your Honor.
Did anyone force, threaten, or trick you into entering this waiver? You offer this waiver freely and voluntarily, is that correct? Correct. Mr. Adams, anything, sir? Mr. Geary or Ms. Rosenwald or anything?
Nothing for the city. We believe that satisfies any conflict with Mr. Arnold.
And as I mentioned earlier, if any conflict should develop, please, notify all concerned at the earliest time possible. And the court will also, if I believe that there is a conflict, I will raise that issue and ask you all to address it. While I have Mr. Arnold here, let's see. Mr. Adams or Ms. Merchant, Madam and Sir, would you like to otherwise waive arraignment on the new indictment? You wish to be arraigned on that today? Or can we go ahead and do that?
We can waive arraignment on that, Judge, and we filed a couple motions on the old indictment, and then I filed a motion adopting all of those on the new indictment.
Hold on
And I
just a
think that would
second,
take maybe
y'all.
about 2 hours to be heard. We'd like to have our renewed bond motion heard with those motions. One is a motion to dismiss based on double jeopardy. One is a motion to dismiss based on a statute of limitations violation. And then one is a motion to sever. I think the sever could probably wait, but the other two dispositive motions would probably make sense to be heard at the same time as bond.
Okay. When did you file those, Ms. Merchant?
I filed them in late June, early July.
Okay, if you'd be so kind, you may have already, if you could send Mr. Kearns, my staff attorney, a copy of those as well. And I will take a look at those and we will determine if I can hear all of them on the 8th. I'll endeavor to do so, but as I mentioned, there's a lot going on. So I'll at least hear the bond. We can wait on the severance and I'll see if I can hear the other two at that point in time, because I would concur that they probably need to be heard up front, but more to follow on that, okay?
Great, thank you so much, Judge.
All right, I will go ahead and authorize you to waive formal arraignment, enter a not guilty plea on behalf of Mr. Arnold, and otherwise give you at least 30 days from the receipt of the new discovery or additional discovery to file any additional motions in this case. And we'll hear the motion for, I'll authorize the your motions that were filed in and under the prior indictment ending in 273 to carry over, otherwise the state's going to file a motion in order for those, and I will adopt those, and I'll authorize your motions to carry forward into the new indictment ending in 572.
Great, thank you, Judge. And the date on that was the 7th of July. I just checked.
Okay. And that would be, and then I will, it'll be the 8th of September.
Okay, great.
For those motions, okay?
Wonderful. Thank you so much, Judge.
All right. Mr. Adams, anything else, sir?
No, yeah, thank you.
All right. Thank you all for your patience. Really appreciate it today. Ms. Rosenwasser or Mr. Geary, anything else as it relates to Mr. Arnold? All right. Then I will release both you counsels as well as Mr. Arnold, and we'll see y'all on the 8th of September, okay?
Great. Look forward to it. Thank you, Judge.
Thank you, madam. Take care.
Take care.
So they got to go back to court on the 8th. For people that's just coming in, they doing like motion hearings for their lawyers and getting it understood. Like,
Yes, ma'am. Unless you have anything else, Mr. Greer, I think I've excused him already. And I've also excused Mr. Arnold. Yes, sir. You may be excused. Thank you, sir, for thank you for your patience. Okay.
Thank you.
All right. Okay, do we have any other waivers, that are meant that we can address today, or any other people that I have not failed to address as of yet?
Just got it. On the second calendar position for the waiver, he does not have an attorney, he's using DOC custody.
I don't think that we have dealt with him as of yet.
He doesn't have an attorney, he's in DOC custody, we provide that.
He is not on the platform today, is that correct? Okay, all right. We can set him for for the 8th of September.
We need a waiver, whether you want a waiver.
We can do a waiver and arraignment if he has in fact counsel. We don't know.
This should have to be a process, bro. Yeah, this live.
Your Honor,
Yes, who's talking?
hi, my name is LaShonda Bishop. I'm here with, Blaylock at Wilcox State Prison.
Wonderful, okay.
I believe, my understanding, he was represented for the purposes of a waiver. I'm not sure if that attorney is here today, but they may be able to do it if that attorney is here. Mr. Lael?
Ray Leo?
Okay.
I'm here.
Hold on, let me see if I have you right quick.
They have a lot of evidence that they
Mr. Lael, let
claiming
me
in
go
this
ahead,
case.
Wait 1 second here. I'll put you
We
in.
gotta wait and see what happens for real, for real. This is coming from the 11 Alive YouTube channel. I'm gonna speak afterwards some more after this is over. I don't think this shouldn't go all day like the last one did.
Mr. Blair, is there any way you can turn your camera on at Wilcox State Prison, madam? I can
Yes,
see.
sir, give me 1 second.
Okay, wonderful. Thank you, madam.
Sorry.
Prosecutors is not playing, bro. They really going for the gusto in this case. It's hell. Like the prosecutors is on another level.
No, ma'am, I just see Wilcox State Prison, that's all. Let me see if you're showing up any other place. I don't believe so. Let's see.
You still got the camera, they say at the top. Oh.
Okay, can you see him now, sir?
Yes, ma'am, I sure can. Thank you very much.
Okay. His last name is
Blaylock. That's my last name.
Blaylock, his first name is Damon.
Mon Baylock. Mon Baylock. He already in prison. I think they said Wilcox State Prison. For the people that just coming in, Gunna already went to court this morning. Thug is in here right now, top right hand
Mr.
corner
Law
on
and
this
Mr.
screen.
Blaylock, thank you for your patience with us today, okay? I am Mr. Law, good afternoon, sir.
Hello, Judge. Thank you.
I'm in possession of a letter that was authored by you on the 31st of 2022. That's the one I'm going to refer to Mr. Blaylock and ask him some additional questions, okay?
Yeah, May 31st, Judge, that's correct.
Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? You solemnly swear or affirm the evidence you shall give in the matter now hearing to be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes, sir.
Okay, thank you very much. Mr. Blaylock, I'm going to ask you some questions. I'm holding a letter that I'm referencing that was authored by your attorney, Raymond D. Law, and that would have been on the 31st of May 2020. Do you recall that having conversation about this letter?
Yes, sir.
Okay. I'm going to ask you a couple of questions about it. I know that you had privileged conversation about it. I'm not gonna ask you any specifics about that particular conversation, only the aspects of the representation involving Mr. Steele, okay?
Privileged?
Yes, sir.
Okay, all right.
That sound crazy,
So,
but we
The
can't
letter
jump on
reads
guns,
that
man.
that he being Mr. Wall is writing you pursuant to your conversation on Friday afternoon, May the 27th, 2022, concerning Brian Steele's representation of you on direct appeal from your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in Fulton County Indictment number 22 SC
Hold on just a second,
182273,
y'all.
for which you are named as a co-defendant. Is that the conversation that you had?
Yes, sir.
Okay, hold on one second, folks. I'm having a lot of chatter with someone else. Just see if there's anybody else that's. Mr. Lyles, I'm gonna mute you.
Hello. Hey, this China.
Okay. We have some other people on the platform we're having to mute because, and that's why we're having some issues with, I think I can hear now. All right. Sorry for that, folks. Okay. So, Mr. Blaylock, did you have a discussion with Mr. Wall in regards to the issues the court just brought up? That would be the appeal of your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in indictment 22 SC 182273.
Yes, sir.
Okay, and that particular case has also been re-indicted under 22 SC 183572. You understand that, correct?
Yes, sir.
All right. Did Mr. Law advise you as your independent counsel that you do not have to waive any issue regarding this potential conflict of interest and that you can object to Mr. Steele's representation of Mr. Williams if you desire?
Yes, sir.
Okay, I'm gonna ask you another series of questions that were not in the letter that Mr. Law penned to you or discussed, but I want to make sure that he did in fact discuss these things with you, okay? Your satisfaction, all right? And
Yes, sir.
I just want to make sure. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, sir.
You also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other.
Yes, sir.
You also understand that the lawyer may want to use a defense theory, witness, or evidence or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client.
Yes, sir.
You also understand that during closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client. You understand that?
Yes, sir.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, sir.
And the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
I understand.
Okay. After the explanation that Mr. Law gave you, as well as the questions that the court has asked you, and that would have been on May the 27th of 2022, plus the court's questions that I've asked today on the 18th of August 2022. Do you give this waiver knowingly, freely, intelligently, and voluntarily, and waive any potential conflicts of
I'm
interest?
gonna give y'all an update just a second.
Yes, sir.
And that it's your desire to do so. Is that correct?
Yes, sir.
All right. Mr. Adams, anything else, sir? All right. Ms. Rosenwasser?
Yes, Your Honor, I noticed that the court used the language former client. I want to be clear for the record and for Mr. Blaylock. To my understanding, Mr. Steele is actually still currently representing Mr. Blaylock on Mr. Blaylock's appeal. So it's actually two current clients. So I want to make sure that, Mr. Blaylock is aware of the conflict arising from the fact that he is currently represented by the same attorney that Mr. Williams is being represented by, and that he wants to waive that conflict.
Let me ask Mr. Adams, okay? Mr. Adams, do you want to address that, sir?
Yes, so that is accurate in regards to the appellate matter. Mr. Steele currently represents Mr. Blaylock, and I do not have any objection to the state asking, I guess clarifying.
Go right ahead now, he's under oath.
Mr. Blaylock, you understand that?
And now,
You understand that you are currently being represented by Mr. Steele on your appeal.
yes, ma'am.
Now, all of those potential conflicts that the court explained to you earlier, and you just raised former client, you
I'm
understand
gonna
that
talk
that applies to you as
talk
Mr.
on this
Steele's
some more
current
after
client and
this.
Mr. Williams is Mr. Steele's current client.
Yes, ma'am.
Do you still wish to waive any objection to Mr. Steele representing Mr. Williams, since he is already currently representing you?
Yes, ma'am.
And you understand that the matter he's representing you on is related to the matter that he's representing Mr. Williams on?
Yes, ma'am.
Do you still wish to waive that conflict?
Yes.
Thank you.
Okay, Mr. Law is, I should say Mr. Adams, who is representing Mr. Blaylock at this point in time? Is he,
I do not believe he's currently represented by. I believe
Mr. Law, is that correct, or Mr. Leo? I'm sorry if I mispronounced your name, sir.
It's Leo, Judge. It's Leo. Thank you.
Okay. Sir, or were you engaged or hired to represent Mr. Blaylock solely for the purposes of the waiver?
That's correct.
Okay, so you do not represent him on the current matter, is that what you said?
That is correct.
Okay, all right. Mr. Blaylock, what I'm gonna do is, I'm gonna set your case over for the 8th of September. We'll see if we can still get you, an attorney. I can't formally arraign you at this point in time. I'll have to wait until that time, till counsel's appointed, okay? Or if you hire an attorney. So if you hire an attorney between now and September the 8th, you can let us know that. But if not, what I'll do is we'll see if we can get somebody to represent you, okay?
Yes, sir.
All right. Any other issues, Mr. Adams or I should say, or Mr. Rosenwasser, anything?
nothing on that.
Okay, Mr. Law, anything on from your perspective, sir?
Yes, sir. That's all I have today, Judge.
All right, thank you very much for your patience with us today. I know it's been a little bit long time being on Zoom. Thank you, Mr. Law, and if there's anything else, I'm gonna release you at this point in time. Mr. Blaylock, we will put you back on for September 8th, and hopefully we'll have an attorney by that time for you, okay?
Yes, sir.
All right, thank you, sir. Take care. All right, anything else, or any other folks we can conduct waiver issues with?
I know you had waivers. I don't know if Mr. Stillwell's on the platform today, but I know he had some conflicts, and I saw his attorney here today.
Let me see.
Mr. Stillwell Jackson I have not seen him on the platform yet, so I'm not sure if he can. Mr. Sharp, who represents him, was present.
I know Mr. Sharp was here earlier.
Oh, there he is.
Oh, it is Mr. Sharp. Okay, all right, wonderful.
I don't think Mr. Stillwell was on the path. And we're ready. I don't think he's on the phone.
I don't think he was on the, let me see if he is. Mr. Chamberlain, do we have Mr. Stillwell anywhere on any one of our,
I'm sorry, I was thinking about who he had conflict for, and that's why I thought of him.
we can can put Mr. Stillwell on for the 8th. Mr. Short, will that work for you, sir?
It will, Your Honor, I do have a matter of business when it's appropriate, I do need to bring to the court's attention, along with attorney. But whenever that's appropriate. But as far as
We can handle this in about 10 seconds, sir, if I may.
Okay.
And I told counsel this because of things that we get communicated that are then put into the social media public. I have informed most of the council that I'm communicating in open court. I can't have everything that's happening here on social media. So Mr. Short asked me a question and I basically responded. I'm only going to respond in open court and nowhere else. I will answer his question without revealing a concern we both have. And I will tell Mr. Short, at this time, you are clear. There's no conflict. Okay, and I'll just leave it at that, Judge. I think the issue is resolved, and I've communicated in open court.
Okay. I know that the state filed a motion on that, a motion. Would you be so kind, Mr. Geary, within the next 4 or 5 days to file an order to that effect?
We will.
Okay, all right.
And multiple copies too. We're learning.
Yeah, okay, all right. All right, Mr. Short, does that conclude, or your issue?
I think so.
Okay.
As long as the state's okay, I agree with it.
All right, so they're gonna do an order, basically withdrawing or otherwise satisfying they have no conflict in terms of your representation, Mr. Stillwell.
This is not on the one it's filed for. This is a separate question that you want to bring up to the court that I would not answer. So this does not pertain to the motion that's filed.
Okay, well, I can't deal with that one until we have, in fact, get Mr. Stillwell. I don't think he's on the platform today.
So they missing
So
somebody.
we'll have to put him on for the 8th.
They gonna be back next
Okay.
month on the 8th.
For rearrangement and for the waiver issue.
To be clear, so we have a conflict of the last against this process. I think we can believe through waivers, but we also, Mr. Stillwell has a conflict with Mr. Steele. So
This is
part
on
of Mr.
11
Steele's
Alive YouTube channel also, when y'all wanna go back and watch the whole thing. 11 Alive
That's fine.
YouTube channel.
Mr. Adams, anything on that? Is that correct? Okay, what I'll do is, let me put that on for the 8th. We'll get Mr. Stillwell produced at that point in time, and I can deal with the rearrangement and the 2 waiver issues at that point. Ever, you got those down? Mr. Chairman? Yeah, we'll need to put them down for waiver and for arraignment, okay? Okay, all right. All right, anybody else?
After Mr. Williams, I think that's really the only one we're going to today, Mr. Kendrick, and Mr. Stillwell, and one for outstanding that I understand will handle.
Yes, sir. Yes, sir. Okay, are there any other waiver issues that I've not dealt with today, folks? That we were able to deal with, because some people were not, either produced on or not, we're gonna get from the state system.
So the waiver thing is basically the guys who are having the same lawyer, they letting them know that, hey man, like, do you know what you doing by having him in as a lawyer representing both of y'all? And you have to agree to that. And you also have to agree to, like, that they're not forcing you to do it. And you basically just saying, hey, I understand everything that's going on with the lawyer representation that we have it. So we got the same lawyer, and let's say this did happen. Not saying that this is going to happen. I'm just saying, for instance, this is what they read off themselves. Like, you are understanding that the lawyer that you have is representing Mr. Williams or somebody else, etc. It can be anybody. They could cut a deal for them that can actually hurt your case. Do you understand that? You have to agree to that. They basically just going and speaking on the conflict of interest of them having the same lawyers and stuff like that. That's in the simplest terms I can put it, to my understanding. So here we go.
We'll deal with on the 8th hopefully we'll deal with on the 8th of September. I also have, okay, hold on. He's not been arrested as of yet, Edward. You talking about Devorius Bradford? Mr. Bradford hasn't been arrested yet. Okay, did we ever locate Mr. Myrick? Yeah, I asked, Lieutenant Dooley, was on with us.
Y'all go subscribe to Studio 56 right now.
To deal with some other, unrelated business. And,
How can I help?
did we find Mr. Myrick?
He's on 7 South.
He was on 7 South 113.
Nope, 7 South 602. Let me call again.
Studio 56 podcast in the building. Y'all know we do that every Monday. Content dropping on there right now for Monday's podcast. We'll be back next Monday.
Thank you for your patience.
As we always say, innocent until proven guilty. Innocent until proven guilty. I'm a firm believer of that.
Mr. Chamberlain, any other holes or inquiry you want to make, sir?
Well, we need 174 more, bro, to get to 100.
Mr. Geary?
I mean, to get to 200.
Hold on, sir.
Y'all get us to 200 likes, man. Get us to 200. My boy say get us to 200. Fuck it. Say we need 170 more to get us to
Nichols,
200.
are you on the
Let's get
platform,
it.
sir? I don't believe Mr. Nichols, we have him present on the platform. So I will have to bring Mr. Nichols. I don't think he has an attorney either, does he? All right, we'll put him back on for the 23rd. I mean, for the yes, sir. The September 8th calendar.
All of these organized gang charges were not created for us. We're
Do
just.
you have a number I can call you really quickly?
You have a number I can call you on very quickly. My bad, I spoke over there. I be trying not to
613-8741.
speak over them, but man, y'all know I gotta talk my shit on this hoe too. Like I can't just sit here and watch this motherfucker.
Yes,
So for the people just coming in, this is Young Thug up here to the right hand top corner of the screen. Duke came in earlier. Somebody who's already in jail. I don't know his street name, or rap name, or nickname. I don't even want to say street name, just his rap name or nickname. He came in. He's already in prison, and he sounded young. I couldn't see him though. They didn't show it. This 11 Alive. They didn't scroll in on his face, but the nigga sounded like a young nigga, and him and Lil Duke understood the waiver situation. Gunna was on earlier. He had a court appearance too, and I didn't get to catch his.
They'll call me. They just said that they'll bring Mr. Myrick out in just a minute. Okay. All right. Is there anything else we can deal with in the pendency? Any other issue? Any other?
I think we only have Mr. Myrick and Mr. Gordon left to get that thing down to 2 o'clock.
Yes, man. That's about 15 minutes from now. Yes. Okay. All right.
Jay Shad.
We can, and I will. Mr. Adams, at this point in time, do you have any? Hold on, one second.
Jay Shad is speaking facts. We're casualties at war with that Rico shit, if you want to be honest. The only thing that we had that was kind of, they wouldn't even infiltrate, but was having real effective motion was the Black Panthers.
You still want me to have that today?
Yes, sir. I've had a chance.
But Jay Shad is speaking facts.
We would like to see forward our motion.
Sure. Okay. All right. Just give me a minute. I'm just gonna recess in place, Mr. Geary, and that all, if you don't want to take a break, that's fine, just come back in about 5 minutes or so, okay? Thank you, we're in recess.
We do it all over here, man. We been live streaming. We just be live streaming our own shit. I live in Atlanta. The case ain't weak when niggas tell it. Yeah, nah. Ain't no case. Ain't no case weak when they got 28 niggas on it. I ain't gonna lie to y'all, because some niggas is ready to talk soon as they go to that room.
Hello?
We just gonna keep it 1,000. So they taking a recess right now. I'll go back a little bit and show y'all some stuff from earlier.
Yep.
I thought of that. Have been threats, man. I want to be with the court.
They're in recess now, so I'm gonna go back earlier and see what's
Speak
going on.
here. Let's see.
The South Annex, it should say.
We're gonna put up whenever he gets on to talk. This is the prosecutor, and he's going for the gusto, nigga. He trying to home run every single thing, nigga. So that's everybody in there right now.
Appreciate you telling me that, Mr. Geary. Okay, all right. So, Mr. Siminoff and Mr. Eppinger, we'll go ahead and put it back on for the 8th of September, and we'll see where there's some other ancillary issues that I need to take up, but we'll wait on that on the 8th of September, okay?
Yes, and that concludes my business.
Gonna put it on when the prosecutor goes up, so y'all can get caught up on that one.
Order for each particular defendant, null crossing the indictment.
We will do that, Judge.
22 SC 182273, and then that would, the superseding indictment would follow, would be fine. So yes, if
No
you,
objection, and the court grants it to provide those orders.
do I hear any objection from any of the aforementioned councils or their representative parties? Mr. Steele?
Has appeared on social media, TMZ, other such sources.
Okay, this is 11 Alive YouTube channel. If y'all want to go back and watch this, 11 Alive, the logo's on the back right hand corner. I'm at a link in the description. Go subscribe to this channel. They the ones that's giving us this live stream for the whole, YouTube platform. But I think right here they're gonna talk about those actual whatchamacallits hitting the internet. So here we go. We make sure they not back live yet. Hold on.
Subject to that, I'll grant the motion to transfer the current discovery that is found and motions that are found in 22 SC 182273 into the new indictment or the re-indictment 22 SC 182273. And Mr. Steele, I have noted your objection.
Thank
you. Okay, all right. And I'm still going to leave the case on a 9 January 2023 posture for trial. Okay, all right.
They still on recess.
Does anybody else, any other defendants have any specific objections as to the re-indictment and the transfer of any of the discovery or motions that have been filed? Anyone else? Okay, all right.
I'm sorry, Judge.
Yes, go ahead.
Thank you, Judge.
Mr. Geary, if you and your team would just prepare a suitable order for that, I can sign it, then we'll give it back to you. You can e-file it, okay?
No later than tomorrow.
Okay, that's fine.
Also, I wanted to bring the court's attention, we filed a motion basically to restrict. We have found that some of our discovery that we have filed, so the court's aware, we have put the discovery in a Dropbox, and we have given only the ones that give our attorneys right now access to those Dropboxes. That discoverable information has appeared on social media, TMZ, other such sources. We filed another motion to restrict, to prohibit such things, not to prejudice the defense, not to threaten witnesses. As a result of that release, one of our witnesses is now basically in isolation and protective custody, as him and his family have been threatened. And again,
Y'all heard that?
aware of who, and I'm not making a threat allegation against any particular defendant at this time. Just know that there have been threats made. I want the court to be aware of that. Judge, with the possibility, I'll put it that way, of trial starting between January 1st and the end of April, predicated on 2 speedy trial demands in existence, we're going to file a motion here shortly for a questionnaire. We want the court to be aware of that. We think that will expedite and really streamline jury selection. We want the court to be aware of that. And we're also going to, if the court has the ability to narrow it down, and I respect the court's schedule, given the number of witnesses we've
Hold
got.
on just a second, y'all. Let me put something real quick.
The defense is going to have some of the same considerations. We'd like to know when and if we could get a date certain to at least start jury selection so we can produce those subpoenas and not slow down the trial as a result of our failure to anticipate documents. I just wanted to put that out to the court today.
Okay, so those are the 2 motions outstanding right now. The more immediate one is the motion to restrict discovery, and then the one that's, that you'd like to forecast out a little bit would be the motion for a questionnaire. Okay, all right. I'll need to probably set both of those for hearing, so to give all the other related and interested parties an opportunity to respond. When did you file your motions to restrict discovery and for the questionnaire? The questionnaire hasn't been filed yet. I understand that. That's coming.
Monday. No, for one. Monday, Judge, it was filed Monday and served.
Okay.
Basically, we found a lot of information concerning one of our witnesses, basically on a TMZ type outfit in social media. We've had to put one witness in isolation and protect custody.
I can hear that on the 8th of September. Okay. All right, so I will hear that motion to restrict discovery on the 8th of September. Okay, 9 o'clock.
Your Honor, in that vein, Kristen Nove on behalf of Mr. Kitchens. Mr. Kitchens objects to the state proceeding via proffer. We want to know what specific threats there are. For example, if something's posted on social media and a witness says, somebody comments, that's ridiculous, somebody should push you off a cliff. That's very different than a direct threat to the witness. So we can do that in camera. We can do that if the court prefers, we can do that in chambers so as not to put the witness's name out there. That's fine, but there have been many allegations that there are threats to witness, and to date, we've received no discovery, not a single shred of discovery of a witness who is actually threatened and evidence of that. So we requested this time that the state produce some witness, some document, some screenshot, something, so that this can be actually verified when we hear this issue.
All right, Mr. Geary.
If these were actual charges, I probably would agree with counsel. They're not. The statute permits us to do an ex parte reveal. We have done that. We would not want to reveal it even to defense counsel, given the danger or potential danger of these witnesses. So the court's aware of what we know at this point in time as permitted by the statute, and that would respectfully be the plan that we would expect to follow. We don't want to further endanger. I don't know that we will. I made it very clear that I have no information that a particular defendant has either made a threat or arranged for a threat to be made. I don't know how much clearer I can make that they want to know who some potential third party is that I can't even identify in all situations. I think is not relevant. I think the threats are out there. We can make the court aware. There's even been a threat to our sheriff and his wife that they would be killed. That when we identified the perpetrator and that person is in custody, it is actually a relative of one of our 28 named defendants. The court's aware of that one as well. So we follow the law on that. The law does not address us giving this information if it's not a specifically named charge. And for that, we have not given that information.
Okay, Ms. Novi, I'll take it up when I hear the motion on the 8th. If you have any written or other law or that you'd like to present to the court for my consideration, just please send it to myself and Mr. Kearns, the court staff attorney, prior to the 8th of September, okay?
Thank you, we will.
All right, thank you, madam. All right, anything else on behalf of the state? So I just have the motion to restrict, and I'll take care of that on the 8th of September. Is there
Let
any
me
other
see if they
things
back
that I need
live,
to-
bro.
We
Hold on,
haven't done
y'all.
the proffers yet. Do we have any other motions outstanding that I need to schedule?
Judge, the only thing we have is that motion to appoint, we'd ask C3 to be present so we can ensure defendants have counsel and have enough time to discover, prepare for the court's trial. That's the only thing we have pending right now that we filed, but again, we're gonna file the one on the questionnaire and, the special set, we're gonna file
Hold on,
that
just a
before the 8th.
We have, the court has also inquired about from Ms. Bernard, and Gina Bernard, that is. And I don't know what the posture is on getting some of these folks attorneys. At this point in time, I have been told that there's a couple things going on. One, that we have counsel that they're having a difficult time procuring counsel. That'd be the best way I could kind of overarch it. So, is there anything else to add on that?
Gotta have
issue?
it came back from the recess yet, so we can chop it up real quick.
Yeah, the court has this, I said that,
Let me see if they showed the part what Gunna was on here. Hold on.
That we've requested from the state, as well as we still, to this day, have not
Gunna's in the
received
bottom left-hand
any-
corner.
any discovery about this nurse who allegedly tried to provide some kind of contraband at the Fulton County Jail.
we're not here to argue that. I'll take up that on the
No.
8th.
No, Your Honor, I'm not attempting to argue it. I'm just,
So they're talking about this discovery, the thing with the court, but they gonna have to wait. And that shit ain't happening until the 8th though, where they said Gunna tried to get the contraband in the jail, which that shit right there seems real shaky to me. Like that shit don't even sound right. How the hell y'all just gonna throw that on him and say that he got the girl bringing shit in, but we'll see.
5 folders that cannot be downloaded. We've tried it numerous times.
Okay, which 5 folders are you talking about?
It is the folder 16 through 20. The title of the folder is 16 through 20. 56 through 59, 79 through 81, 85 through 87, and 73 through 76. Those are the folders that we cannot access. So we don't need the whole thing, just those.
Mr. Gary, Mr. Smith, do you have one of your tech folks available at the conclusion of these proceedings so they can go ahead and facilitate those particular downloads?
Judge, if we've not received that particular information. If we can get that information for them and they want to provide a hard drive.
You just did. They just did. So can you do that after court?
I didn't write it down, Judge. If she'll email those to me, yes, Judge, we can do that.
Okay. Wonderful.
And in fairness, we did email the state about this on August 2nd. So we just have not received any response to that.
To pose the questions to those individuals or whether you want me to do so.
Okay, I have Mr. Williams. You are Jeffrey Williams, who's born on August the 16th, 1991, is that correct?
Yes, sir.
All right, it says you consulted with Attorney Keith Adams on the matters contained therein, and you state basically as the following, okay? That you are the same Jeffrey Williams charged in indictment 22 SC 182273, and that was the prior indictment in this case. Is that correct, sir?
Yes, sir.
You understand that your case has been re-indicted in 22 SC 183572. Have you had the opportunity to speak with your attorney about the new indictment?
Yes, sir.
Okay. It also references that you're being currently held, and right now you're in the Cobb County Detention Facility. Is that correct?
I'm in Cobb.
Okay, but yeah, that's what I said. You're in the Cobb County.
Yes.
Cass County Detention Facility. And this contains the indictment 22 SC 182273. And that case has been re-indicted, as I mentioned, in case ending 572. So that's correct. Is that right, sir?
Yes, sir.
Okay. And then number 3 says that you've received, read, and understand the charges contained in the reference indictment. And you're aware that you're being charged in the indictment with other individuals. Is that still your understanding?
Yes, sir.
All right. Number 4 represents that you're currently being represented by Attorney Brian Steele and Keith Adams, and that you've been represented by Attorney Brian Steele since the date of your arrest on May the 9th of 2022. Is that correct?
Yes, sir.
It also references that you have been represented by Mr. Steele in other legal matters and unequivocally desire his continued relationship. And you also established a trusted attorney-client relationship with Mr. Steele. Is that correct?
Yes, sir.
All right. It also references that you've had daily meetings and consultations with Mr. Steele and Mr. Adams regarding your case and specifically your defense. Is that correct?
Yes, sir.
All right. And then you met with Mr. Adams, number 6, independently and outside the presence of Mr. Steele concerning any potential conflicts of interest regarding Mr. Steele's representation of other persons named in the indictment as well as you. Is that correct?
Yes, sir.
All right. Number 7 references that specifically Mr. Adams has discussed with you the specifics of the State Bar of Georgia rules pertaining to conflicts contained in the Georgia Rules of Professional Conduct, specifically 1.7, 1.9, and 3.7. And Mr. Adams has discussed with you thoroughly and completely the issues related to any potential or alleged conflicts in this case. Is that correct?
Yes, sir.
All right. Number 8 references that based on your discussions with Mr. Adams, you're unequivocally waiving any null conflicts and desire in no uncertain terms for Mr. Steele to continue to represent you in this matter. Is that correct?
Yes, sir.
Number 9 references that you're aware that Mr. Steele has represented other persons in this indictment, and notwithstanding any relationship Mr. Steele may have or may have had with any other person or persons contained in this indictment, you waive any potential conflicts. Is that correct?
Yes, sir.
And then number 10 says that you met with Mr. Steele and discussed that what we've discussed here, after review, the state's motion to disqualify Mr. Steele as your counsel, and that you have stated to Mr. Steele unequivocally and without reservation, and you state to me, the court, that you waive any potential conflict and wish for Mr. Steele to remain as your chosen counsel. Is that correct?
Yes, sir.
All right. Anything else, Mr. Adams?
I see when they talk to Gunna. Let me see if I can find that part. I don't see it. There you go. When they talk to Gunna. It's on 11 Alive YouTube channel. So make sure y'all go subscribe over there. Y'all can catch this case. Kevin Lyles is in there. Hey, bro, this is really some deep shit, bro. This is really some deep shit. Hey, my nigga. This real life. Niggas' life on the line, nigga. I expect any nigga to say yes, sir, or yes, your honor, nigga. You better know.
Okay. Yeah, I can see you. I was telling you just tell my family, we booked the busy.
Uh, 1090 Jake. Hold on, y'all. Let me cut the hell out real quick. 1090 Jake actually dropped a video if y'all want all the documentation on Lil Woody. Now, that doesn't mean that he's going to snitch. He can also retract his statement, but his name was the one that was on that paperwork that was flirting around. And then whatchamacallit came out and confirmed that those discoveries were real. His name was in there, and the part about the murder of Peanut was these things. If you you scrolled up and read it, the people already depicted it, deciphered it all on the internet, went viral for a couple of days. Miss Fonnie Willis, the DA out of Fulton County, who is, been speaking, the black lady, she confirmed on the news that that discovery was real, and they have now put him in, they're going to have to put him in protective custody because him and his family are receiving threats online and everything like that, which you don't know if these are just fans, but it's now a thing. So 1090 Jake actually pulled up all the paperwork on his channel. So I guess we'll look at a little bit of that when we done. Hey, this is what happens in this game, though, bro. This is how it works. Now, that doesn't mean he's going to go through, but he has given up some information as of right now. But he can backtrack it. That's a decision that he'll have to make. But all this shit right here, this courtroom, this is all part of the streets, bro. Just know that. All this go with the streets. All this go with the streets, bro. They got they got a lot of information from what they saying though. So I like to wait and see what's undeniable. Like, hey, bro, you did that. You went in there, took it all the way to the highest level. I remember in that Boosie case, the young guy was going to tell in that Boosie case, and hold on, let's put it back on there.
And so, okay, that's fine.
Let me see if it's back live.
Ms. Novak, you still want me to go through the waiver with Mr. Kitchens? I think we should as well.
Okay, let me mark this spot.
Mr. Kitchens, let's see if we can unmute.
All right, we back live in court. 138-minute mark. We'll go back and see what they say to Gunna when they address him directly. The judge does. So y'all can see that, and then we're going to go back live right now. Innocent until proven guilty, like I always say, though, man.
No, Your Honor.
Okay,
back live.
Mr. Myrick, I'll release you at this point in time. Mr. Theory will come to the jail and talk with you, okay? All right, thank you, sir.
I'll rewind it a little bit.
All right, good afternoon, Mr. Myrick. Good afternoon, Mr. Theory, and good afternoon, Mr. Geary. This is Mr. Theory. Your client was originally brought over an indictment 22 SC 182273, and that matter has been re-indicted in 22 SC 183572. Are you aware of that?
Yes, Your Honor.
Okay, all right. Do you wish to go ahead and waive formal arraignment and the new indictment? Otherwise, have the court enter a not guilty plea on behalf of your client and have at least 30 days upon the received discovery to file any motions?
Yes, Your Honor. We would ask to waive formal reading and to get the 30 days to file motion.
All right, I'll put it on for January the 9th of 2023. Sir, have you filed a, motion for bond or anything such as, any other motions pending?
Not at this time, Your Honor.
Okay, all right, if you should file, any motions, please let Mr. Chamberlain know. And I'll go ahead and, we'll see if we can get you scheduled accordingly, okay?
Yes, I will send courtesy, motions to Mr. Chamberlain.
Okay. Sir, let me just ask you something. Are you gonna be asking for bond in this particular case?
It's likely that I will be going to visit Mr. Myrick and, we'll go from there, yeah.
Okay, all right, I'll wait then, all right? Okay, just wanna make sure.
Yes, sir.
Okay, do you have anything else, Mr. Theory or Mr. Geary?
No, Your Honor.
Okay, Mr. Myrick, I'll release you at this point in time. Mr. Theory will come to the jail and talk with you, okay? All right, thank you, sir. Okay. Is Mr. Garlington with us at this point in time? Thank you, sir. All right, Mr. Lewis and,
Good afternoon, Judge. I'm here.
hey, good afternoon, sir.
Good afternoon, Judge.
It's been a minute since I've seen you, but,
Yes, sir.
good to see you. All right, all right, Mr. Lewis, thank you for your patience. I know you've been on a little bit. Mr. Garlington, given the schedule, was only available as of 2:00 since the morning schedule is kind of full. But at this point, he was on for arraignment in, indictment 22 SC 182273. That matter has been re-indicted under 22 SC 183572. Sir, are you aware of that, Mr. Lewis?
Yes, sir, I am.
All right.
My
So
bad,
you wish
Joe.
to go ahead and waive formal arraignment on the new indictment, otherwise have the court enter a not guilty plea on your client's behalf and otherwise have at least 30 days to file motions upon the receipt of discovery?
Yes, sir, that is our request.
Okay, all right, I will go ahead and grant that. Sir, have you filed a bond motion as of yet?
Judge, a bond motion was filed on the prior indictment. Mr. Garlington is
My
serving
bad.
out a very, for technical violations. So it is moot at this point, but at some point I will refile under the new indictment for a bond motion, yes, sir.
Okay, when you do so, let us know, and if you would send all those concerned from the state as well as Mr. Chamberlain and Mr. Kearns, the court staff attorney, any motions that you file or any request for bond, we can go ahead and schedule those. I will go ahead and place you on the 9 January 2023 trial calendar. As I mentioned, any other motions that you file in the pendency, please make sure that you copy the
This
court
ain't
and
even a
Mr.
bail
Kearns,
hearing,
as the
y'all.
court's not an e-file party, okay?
This ain't no bail here.
Okay, Mr. Garlington, Mr. Lewis will be back in touch with you, get you ready for trial, and he'll be talking with you soon, okay?
Yes, sir.
All right, thank you for your patience, and you can be released at this point in time. Mr. Lewis, you have any other business before me?
No, sir.
All right, I'll release you this as well this time, sir, okay?
Thank
All
you.
right, thank you.
Get you ready for
All
trial.
right, councils, were there any other than the bond, or any other folks I need to take up, or any other people that I've missed? Any other waivers, Mr. Adams, or any other ones that I have missed at this point in time that otherwise are not in custody or? Okay, all right. Okay, all right. Okay, at this point in time, we're gonna take up the matter now in, under the new indictment, that would be 22 SC 183572. I'll note for purpose of the record, Mr. Steele and Mr. Adams, that you did file that motion under 22 SC 182273. I will just continue it and, consider it under the new indictment ending in 572, okay? All right, okay. Sir, floor is yours. Go ahead, Mr. Adams.
Thanks, Earl.
This court case will be on, it's on 11, the live channel, but the, 1090J got the whole little case stuff. Y'all wanna go check that out, 1090J, end of sentence.
The defense put up a number of witnesses and put up live evidence before the court. There were proffers made and the state proceeded primarily by upon consideration of all the evidence, including representations made by the state, court denied bond for Mr. Williams. We have filed subsequent to that a motion is before the court today for reconsideration of denial of bond, and we have put in that motion and are here to argue today that there were consistent, numerous, and material misrepresentations made by the state in opposition to bond. This is not an attempt to cast aspersions upon the motive of the state, but to factually correct some things on the record. We believe that the court's denial of bond was based upon several of those representations taken that the court took from the state. And we believe that if the court were to consider information put before it without those misrepresentations, that it would appropriately reconsider its decision to deny bond for Mr. Williams. As you recall, we placed before the court several options that we believe would have satisfied the court under all of the IO factors, and did in fact make out mechanisms by which the court can be assured that Mr. Williams' return to court whenever ordered, without going into any tremendous amount of details. It was a day-long hearing. To put it in synopsize it, if that's the proper word. We of course suggested to the court that at Mr. Williams' own expense, we would arrange for 24-hour law enforcement monitoring of his residence. We offered to the court that his residence could be swept prior to his arrival, to make sure that the mechanisms by which he could communicate that would not be available, would not be known to either the state and or the court. We suggested that Mr. Williams would be amenable to 24-hour house arrest if he would not leave the home absent court appearance or authorization by the court.
And I give you a testimony from Mr. Charles Middlestat to that extent, and a document was introduced synopsizing, your word, his or reducing his plan to writing for the court.
And obviously, I know that the court was attended, took notes and paid attention to all the things that we proffered, all of which we believe should have or would satisfy any court, frankly, in being comfortable in releasing the defendant on bond so that he would reappear for the appropriate process down the road. As we move forward, however, it's incumbent upon me, I believe, to ask the court to take note of what we placed in our motion, and I'm sure that the court, as it always does, has had the opportunity to read the motion that was filed on June 28th of this year.
It's the culture, man.
Yes, sir.
I'd like to go through some of the things and for the record what we believe were.
I'm gonna actually stop at 2 o'clock. though. 2 hours.
And make some corrections for the court.
2 o'clock, I'm gonna shut it down.
There's no evidence to indicate he has any greater access to private jets or helicopters or any other means of transportation that anyone else does not have access to. And given that our recommendation was that he be confined to his home at all times, with the only exception being for him to come under the auspices of law enforcement from the court. We believe that that representation by the state was not one, is not one that the courts should or could seriously consider.
He did mention that one of his residences is near PDK, Peachtree Cab Airport, and that it wouldn't be much for him to cut his ankle monitor if I gave one, and or money to be to be given for him to be able to make that type of that. I think that was Mr. Geary's argument last time, but I understand what you're saying.
Yes, I do believe the argument, and my response simply is that Mr. Williams would not have any greater ability or access to do that than any other individual. There's no evidence that he would in fact do that. Supposition is not sufficient for the reason to deny bond. The prosecutor cited in Overt Act number 4 that Mr. Williams, back in September 9th, 2013, was in possession of a stolen firearm. So I wouldn't consider that to be put that in a different category. I understand there are searches based on the fact that he was charged with that offense, but constitutional guarantees mean more than just words. And in that particular case, I think the state is aware that if the court is not, I can tell you as an officer of the court, that there is no showing that Mr. Williams was knowingly in possession of a stolen firearm in 2013, almost a decade ago. That case is a case where he was charged, and the case was dismissed after successful completion of the pretrial intervention program. Now, entry into a completion of the pretrial intervention program is not an admission of guilt. It is a matter of resolving the case. And I don't need to preach to the court. The court knows this. It's a matter of resolving the case based on practical considerations. There was never the issue of whether he truly was in possession of a stolen firearm vetted or put before any court or any jury for that determination to have been made. And so, because he always enjoys the presumption of innocence, even after he has entered into and completed a pretrial liberation program, I will submit to the court that that assertion by the state is not something that could or should have been considered as a reason for denial of bond. Overt Act number 9, excuse me, and this, I won't go through all of them because this actually addresses some of the other arguments made by the prosecutor, specifically in reference to song lyrics. I know we talked about this a good bit the last bond hearing round, but I really wanted to harken back to that. Overt Act number 9 is referenced by the state concerning allegations that on April 20th of 2014, there was a song titled You, EWW, and that it contains lyrics along the line of all I ever wanted was the money, and that people wind up in wheelchairs. And the prosecution put that before the court as a way of arguing that Mr. Williams is a danger to the community, as evidenced by lyrics in the song. This and other overt acts that reference song lyrics by Mr. Williams or song lyrics, I think is inappropriate for the court to consider as a reason to deny bond for a number of reasons. Number one, there has been and was not any showing by the state that the lyrics that it referenced either in that overt act or any other overt act.
Guess we got to stay trying to get the bond, y'all, for everybody coming in.
Indicating some sort of mindset on his part, or authored by him, sung by him, distributed by him. I think it is tremendously disingenuous and quite frankly very dangerous to take song lyrics where there is no presentation or no representation made about the origin of those song lyrics and use that against Mr. Williams. There are, in this and in several other overt acts, there are, I'm not necessarily suggesting all of them be that the court, number one, go and listen to the actual songs that were quoted, or that the court do any independent research with record labels to determine who actually wrote those songs or who actually, which artists, where there's several artists in the song, which artists actually sing the lyrics that the state is referencing. But I can tell you that we've done that. And as an officer of the court, we know, I'm telling you that we know that there are several lyrics that are referenced that simply are not Mr. Williams and other artists. There's several songs that were not written by Mr. Williams. And so it is not just misleading, but it's dangerous to
ones were not written by him?
And
It's saying Young Thug got ghostwriters for the people just coming in.
there's a song, Anybody. I don't remember which. Let me refer to my indictment.
They saying Young Thug did not write some of these songs.
Lyrics, along the lines of I've never killed anybody that has something to do with that body. That is a song that was written by three individuals, by Mr. Williams, by Nicki Minaj, I forget her actual name, and a third author. And there are lyrics quoted that were not written in that particular song by Mr. Williams. That is one. There is.
Oh, it might have some action, y'all. Might got some action.
And over Act number 60. In Open Act number 60, the state referenced a video released on social media titled, quote, Slime Shit. And the lyrics that are quoted in that is not a song that was written by Mr.
Hey, can y'all still hear me?
There's a different artist who wrote that song, and none of the lyrics.
Hey, can y'all still hear me like this?
Mr. Williams. And
Can y'all still hear me like this? Okay, bet. So, bro, for people that just coming in, man, he making the argument that Young Thug did not write all his music. You know what I'm saying? Like some of these things that they using is in playing in court, the lyrics they read in court, that he actually had help writing these songs, and these lyrics are not all his, that they are actually using to part of the reason why they holding him in court with no bond.
my point is,
Who wrote it?
an artist by the name of Roscoe.
Okay.
Like I can get to the full name if the court desires. Is it?
Jimmy Winter.
Jimmy Winter, I don't know.
Roscoe was on the case too, though, ain't he?
Anybody was written by Mr. Williams and Nicki Minaj and one other person, right?
That's correct.
Okay, all right.
And there's some others that I'll be supposed to and search for. What I'm suggesting to the court is that, and I keep using the word dangerous. The state doesn't say that. The state in their presentation says to you that Mr. Williams did this. Mr. Williams said that. Mr. Williams wrote this. I don't know if they said he wrote it, they said he formally said it. And that's simply not accurate. And so for the court to, asking the court to consider that is dangerous and is inappropriate. It doesn't give the full story. And the court needs the full story. And
Can y'all hear this still right here?
And one of the arguments that the state put forth, that the court actually is particularly interested in, and I'm looking now, paragraph 6, where they reference in Over Act number 25.
Get real.
On January 25th, 2015, there was an audio recording of Mr. Williams declaring that, quote, sacrifices must be made, soldiers must fall in order for the battle to be won. And the state argued that that was a, quote, call to battle for criminal street gangs. Now, I will say, Mr. Gary, when pressed, was not sure whether this was an audio recording in digital format or possibly a group chat. This was not a statement made by Mr. Williams. And as a matter of fact, I think the court asked Mr. Gary about that on 3 separate occasions, about the format of this statement, where the statement comes from. And so I believe the court was misled in that regard, in them saying that Mr. Williams made those declarations that he simply did not. It's not accurate. That's information that the court used to make a decision that is simply not accurate information.
Well, hold on, Mark.
Prosecutor made a claim that on January 26, 2015, approximately 60
Let me read
days
the super
after the
chat
killing
real
of the
quick.
individual,
Mark Lamar said the fact the judge is asking who wrote it is crazy. Yeah, it does sound kind of crazy, the fact, you know, that he asking that, but it's like he got to ask for the court case because of, that's his argument. You know, he trying to fight for the bond right now, and she, you know, it is other writers credited on these songs, so that's part of the game. You know, that's part of it. It's how this shit go.
in the indictment, that Mr. Williams released a video stating, quote, if anybody goes into a courtroom and tells the God's truth, they need to get effing killed, and that this threat still being discussed by witnesses today. That was an absolute misstatement of the information that we've been provided. It's taken out of context. There are sentences that are put together in the representation of the court that aren't in fact together, and it is put forth as a representation for something that it is not. And again, the state has the ability to give the court the entire, whether it's a social media posting or a recording or anything else, the court can see it. But making representations that are not accurate, again, runs the danger of the court being led or being misled about the true contents of any statement allegedly made either by or with the presence of Mr. Williams. And we started discussing what earlier was the prosecutor saying that Mr. Williams has lyrics in his songs containing references to, quote, killing police officers and judges, particularly, and, quote, mob life. And I don't think that was inadvertent or unintended. I think obviously saying that this defendant who was before the court for a bond has authored or other lyrics about doing damages or killing judges is something that's extremely prejudicial, but it's inaccurate. That is in our paragraph number 9, that is the recorded, that is a statement that was authored by Roscoe as opposed to by Mr. Williams. And it's simply not accurate, not true, and not appropriate to say that Mr. Williams is the author of that statement or the person who uttered that statement, and have the court consider that as a reason to deny law. My argument, I guess, Judge, because, and I don't want to limit on time, but I do want to take my time. I also don't want to just belabor the point. What I'm getting at in regards to the lyrics is that if you're going to say that those are things that are important to consider, they've got to be accurate. They can't be misrepresented. They can't be taken out of context, and then they can't pick and choose, pick one sentence from a song, another sentence from.
That's really more of a federal Rico, though. You are correct, though, famous Monroe, but it be like that more on the federal side. State side a little bit different, but you are correct, though. You are correct. Yeah. This is true, though, on the actual to get them charges on that state Rico, though, the stick. To get them charges to stick, they're going to have to come with some real shit on the state, Rico. They say, put your inside. Man, I don't know why. I got to cut my mic down or something, bro. I talk loud naturally. I don't know how to cut this motherfucking volume down on my shit.
That the state argued.
Let me see something.
On matters that I think anyone would consider trial issues. And I heard the court say a little bit earlier that those are issues for trial. And whether or not the person is not guilty, or innocent, or whether someone actually did something that is alleged in the indictment, those are my matters for the trial, not matters for consideration of a bond. And there are several arguments that were made, several things. And of course, again, the court has the at the motion, and the court's had an opportunity to see what we said in the motion. But there are, the majority of the rest of it are things I would say to the court that we disagree with. We think that given an opportunity to vet them before a jury or even before a court, that we'd be able to disprove some of those things for those matters that in regards to our motion for reconsideration. I ask the court to give a careful look at the representations that were made, what we have rebutted in those representations, what we have clarified.
Now, if this case goes federal, it's gonna be tough. I ain't gonna lie. I'm always say innocent until proven guilty, man. That's just why I stand with this type of shit.
Thank you, sir. All right, Mr. Geary, or Mr. Smith, or Ms. Rosenwasser, go ahead.
I don't care what case you get. If you got somebody testifying, it's gonna get real, bro. I'm gonna cut this up a little bit.
Where this seems to go is what he just said they didn't want to do. He's basically saying, we disagree with the evidence that's going to be presented in trial. And that, again, as he did.
Bro, does it seem like he wear the same suit to every court date?
The phone call that he got that he wants to classify about someone to his significant other is kind of troubling because the person living in line was the defendant's sister. So if he is claiming that's his significant other, that's just a whole other issue. They can claim that they interpret the call different. The call is what the call is. He claims he's got what he needs for his detox there at the jail. And that's straightforward, and it is what it is, Judge. If they want to say it's something else, again, that might be a matter for a jury to determine what's on the call and what's not. But that's what the call says. That he didn't author the actual song. But as we get to the trial evidence, that's not the law. The law is if you sing the song, it's an adopted admission. You don't have to write it. But that beside it, when he starts singing, when you start looking at song shit in anybody, I invite the court. Look up on iTunes. It says, written by Jeffrey Lamar Williams. Right? That's everything we see is there. If he wants to come in and say, I didn't like that, that's fine. It's in contradiction of what's out there and what is posted as being the truth. Those songs indicate that he wrote them. Now, that aside, it doesn't matter. If he sings them under all law, it's an adopted admission. So, at the end, the one he said, Wasco, he didn't give you the name on respectfully, I did. That's a Jimmy Winfield, a member of YSL who's involved in these crimes. Every one of them here want to be a rapper. Right now, there's Mr. Kitchens, there's clearly Mr. Williams, and they're very successful at that. Other members of their gang are writing about the exploits of the gang, and Mr. Williams is singing about some of them. The fact that Mr. Williams didn't actually write that I didn't kill anybody, but I got something in their body, is still biographical. He's still in that role. That's still the truth, and we still intend to prove that, Judge. And again, it's an adopted admission. It doesn't take away anything that maybe he's not the one that penned the words. But again, as listed on iTunes and other such places, it says he wrote the song. And maybe he's just doing that to get the credit, but he's going to come and say, oh, that's really not true. Again, it's immaterial. Judge, what this is, and they're saying, okay, he was discharged because he went to pretrial intervention. I don't care. He's still in possession of a stolen gun. And it's still a trial fact for the judge to be able to quote the state to be able to prove that he's aware that he knew it was a stolen gun. And the reality of it is, they have so many stolen guns that we have the ability to show that always possessing these stolen guns, they knew or should have known that they were stolen when they get them, how they procure them. That's a trial presentation, and we're going to be ready for that when it comes, Judge. What they're basically saying is, we disagree with the evidence. So because of that, we say it's a material representation. It's not, Judge. Okay, at least I'll stand in my place as the prosecutor. It's what we believe the evidence.
Hey, bro, this shit get real, dog.
I'm not gonna want, you should have to see when they get to trial, and maybe be like, they may prove that I'm wrong. I may prove that I intend to, but they're wrong. But that's a trial issue. What the statement said in that string, and it's a group chat, to my understanding, I'm wrong twice today, on the judge, I could be wrong again, but to my understanding and knowledge, those words are extremities. So I think what we have here is they've gone through the indictment and they want to reclassify or put defense spin on the evidence in the indictment to say that I'm materially wrong. I still stand behind.
This is from 11 Alive YouTube channel also, y'all. So y'all go check that out if y'all want
If I'm
to.
not mistaken, time they've asked for bond. They were asked the denied bond on 5/11/22, 6/2/22, and I don't know what the court's going to do today. But on 6/2/22, the court denied it on all four bases. And Judge, we stand behind the representations we made. To my understanding and belief right now, they were all correct. They might have a different spin on them. They might be telling or forecasting what their trial strategy is to fight the evidence. But again, that's a trial strategy. I can tell the court, I'm sitting there looking right now at one of the ones for slime shit. It says written by Jeffrey Lamar Williams and Ricky Harrell, Harrell. That's wrong. That's what he's putting out. If he wants to change it, there's nothing I can do about that. Judge will deal with it when we get there. Your Honor, he runs, and I mean he runs, he's the general. He says in the song, he's the general. He runs a very violent street gang that has committed numerous murders. Respectfully, Judge, if he's let out with the number of people that are still out there in YSL, I would expect that to continue. And I would expect witnesses to be in danger. Again, I have nothing specific that Mr. Williams has made a direct threat. This is the gang, members of the gang, relations of gang members here that are in jail on this case have made them. One of them's actually in jail for that threat. And I don't know any way to put it, I don't mean this in court, but this is the real deal, Judge. These are very violent people, these are dangerous people, and I believe the finding on June 2nd is correct. We'll flush this out of trial, but all four of those factors still apply. There has been no material change. There has been no misrepresentation. There's a disagreement with what the evidence at trial is going to show. And I believe then that means they do not count the order that the court signed on June 2nd. They do not carry the weight on what all factors, and I ask the court to deny bond again.
Hey, bro, that prosecutor ain't playing no games, bro. I mean, this what you be up against though when you this heavy, bro. They gonna go for the gusto on you, bro. They goal in the courtroom is to make you look like the worst person ever. That's what they gonna do.
I believe, without any hesitation, there are conditions that can be met that will ensure that Mr. Williams comes back to court when required to do so.
Hey, y'all, is it showing blurry? Is it showing blurry now? I upgraded my internet. Is it showing blurry? Let me know something, y'all. I know y'all got a little bit of a delay. I actually upgraded my internet. I'm trying to see if it's working better. Let me know something. Give me the feedback. This is on 11 Alive YouTube channel. I'm gonna put the link in the description where y'all go check that out. But their goal is to make you seem like you are the worst of the worst. Hey.
Shot. You go into the neighborhood that you raised and other people who come from poverty. I'm sure the court has been shot. He has been hungry. Family helping together as best they could. Grew up in a place that in America, in 1990s, nobody should grow up like that. And he's being ridiculed now because he talks about that life and what he's seen. He should. He's a brain people do hip hop and rap are bringing to the attention of people who have no idea what it's like to be in the inner city growing up. He is educated all of us. He should be applauded, which he is applauded by most. The fact that we are talking about lyrics, songs, and we're going to get a motion from you, that please keep it out. It's admissible evidence. Because I don't see that happening to people who write books. I don't see that happening to people who act in movies or produce movies. I don't see it happening to people who paint portraits. But it happens in music only to people who perform hip hop or rap. To me, it's discriminating. Because I don't see it happening to people who do rock and roll or country music. Same type of lyrics. Jeffrey Williams, Your Honor. I know you don't have the pleasure of. You've heard him today. You've heard him. He's most polite. He's a genius. He understands that we're fighting for his life. He would not risk anything on bond. The fact that Mr. Gary and we all agree, says these are trial issues. They are trial issues. Mr. Gary wants to use it as bond issue. Mr. Williams is presumed innocent of any crime.
Ain't nobody untouchable by the law.
And while Mr. Gary
Nobody.
disagree,
And the law ain't, they gonna play how they play. The law gonna do what they do.
but in bond hearing, we shouldn't even be talking about the
It's
allegations.
lagging.
Those allegations are what they are. They're hearsay evidence that Justice Hudson taught us about.
I don't know why
That
it's.
just put into an indictment and affirmed by a grand jury. So the real evidence you have before you that you have a young man who sits in a Cobb County jail. I see him almost every day. And we work his case every day. And he should be in a house without any internet, without any electronic video, without any access to anyone, except his lawyers or doctors, medical emergency, with sworn law enforcement officers around that house. And we can move him out to the country where no one's around him. First place, and no one knows where he is. That is what we need. I ask you to please grant me bond.
I don't know what's going on with the Wi-Fi, man.
Every day, if anything happens, we can put somebody from the district attorney's office, from the court system.
Or why they ain't playing clear.
In charge of ensuring that
I
those
just upgraded this
officers
internet.
are constantly updating everything. This is that. Your Honor, Mr. Gary, he knows my feelings. He is wrong. He says that Mr. Williams is on some sort of chat group talking about soldiers and people, sacrifices must be made. I have it in discovery now. I didn't have it when you originally heard it. My insight sat there and I can say it because we didn't have the information. But I have it now. I can show it to you now.
It is actually crazy that they actually is discussing lyrics, bro. This is a real thing. I mean, they supposedly have all this other evidence too, but like right now, bro, they in these courtrooms and niggas' lyrics is being brought up on them. And bro, anything you say and do if you are on some criminal time will be used against you. Thug is actually praying right now. It's the real side, bro.
Shooting a bus. You got a bus as a code.
Damn, it's lagging.
He was the one who prosecuted this one.
I actually cut it down right there. I cut it down. My bad, y'all. I cut it down.
There are problems with this case for the prosecution.
I cut it down, y'all.
Are not solved by January 9th trial. Every day for jail is a day. I want to thank you, and I hope I'm going to be some sort. I'm not trying to waste your time.
Wasting my time. It's your job. I mean, and with any of this, I mean, look, there is natural friction between the court, the defense, and the state or the government. That's healthy. So your statements to me, Mr. Adams' statements to me, Mr. Geary's statements, anyone, I understand it. I understand what they mean, and I understand, what my role is in this. And we're going to disagree on certain things, but you can't, no harm in asking. Court doesn't feel offended. Court has the responsibility to listen to whatever's proffered in front of it. And I take that responsibility very, very seriously. And I also understand that with any criminal accused who is pending trial, they are presumed to be innocent. So, I understand that, Mr. Steele, and we may disagree sometimes or disagree, and I'll make rulings which you certainly, as I always tell people, you can have my homework graded. That's the beautiful thing about it. And I won't feel offended at all.
No, there has to be under the waiver. Mr. Williams has access to resources. There has to be a way to allow, satisfy someone in court that he can be granted bond and with all conditions. If you put him in a jail or just outside the jail, he doesn't have to have any type of communication with anyone else. You don't need that. He is in such a bad position that anything would be better. Be better in the case of, well, I know that may not be concerned for the court. It's concerned for me. With that being said, you said last time, before you're on the court for motion for bond, you did all four factors. That said the primary ones, group chat messages from 2015 back in the threat message, that message is talked about. That message, Your Honor, is a statement that is reality. The court sees it, the prosecution sees it, the jury sees it. News media sees it. All he said was, I don't get it. People lie to their mothers, lie to their fathers, lie to their brothers and sisters. And then they come into court, raise their hand, and swear to tell the God's honest truth. Those people should be killed. Talking about it, you look at the date that was made, January 26, 2015. It was a well-known case right there that an innocent man spent 30 years in prison based upon a lie of a well-known town liar. And 30 years later was proven innocent. The district attorney's office dismissed the case. And that should not be a reason to deny Mr. Williams the bond. In the background, you blow up that court. You hear people saying, I'll swear to tell the truth, and then I'll lie on God. We're talking about witnesses lying today. That happens. That's not a reason to deny bond. Your Honor, we will stand in court any type of condition. He will not leave that house, but he should be respectful. Mr. Williams meets with four parties. Respectful. I ask him to grant a bond that he cannot leave, surrounded.
Praying, man. That's all you can really do. I ain't gonna lie, bro. When you up against shit like this,
that was hardship on his family, his friends, but so be it.
I'm gonna cut it down real quick. Hold on. Never mind. We good.
Yes, you may, sir. Yeah.
I ain't gonna lie, dog. You gotta pray. Cause the only thing that can help you get through this shit is God, my nigga.
One of the reasons we re-indicted was to add charges from the arrest on May 9th. And one of those charges is possession of an automatic weapon. And there are other weapons in there. Now, as we stated, Mr. Williams is not a convicted felon who can have weapons. He can't have an automatic weapon. And there's other drugs located in the house. And I believe there was also a small child in the house there with those weapons and those drugs. Now, quite frankly, the case that we see, and the person Mr. Steele just spoke about, those things don't do this. They're not, that's not accurate. This is a dangerous person, and I don't, Mr. Steele's got a job to do, as the court said, and I respect both Mr. Adams and Mr. Steele for doing their job. But that's not real. The real world is where we live in here in Atlanta. And YSL is a dangerous gang, and this is the man who leads that gang, and he's dangerous. And I ask the court to reaffirm your findings in June 2nd, and I want.
Yes, sir.
That's how I get, man. All the nigga
Can
can
you do
do
it
is
another
pray,
minute?
bro.
Because you will wax on if I don't cut or give you a timeline. Okay.
Got 1 minute.
The 14-year-old child, Mr. Williams, has custody. That's his son, that in the home on May 9, 2022. The gun that Mr. Here is talking about, law enforcement officers around the house, they were not in uniform. People in that house, multiple people, actually, 10, 12 people in the house. My number was a little wrong, so I apologize. The surveillance around the house, the person who exits the house, not Mr. Williams, with that gun, that's not Mr. Williams. So to sit here and say it's Mr. Williams' gun is wrong. And that surveillance video, I presume the police have it because they know it's home. In addition, Mr. Williams self-surrendered to them. He called me. He said the police are surrounding my home. He said, surrender. I'll come over. He said, okay, that's what he did. Then finally, Your Honor, I hear what you do. He tells me this, he tells me off the record, not on the record. He always tells the same thing. Mr. Williams is a part of this gang. Mr. Williams is a role model to both. He is a non-gangster, but he grew up in an area that he understands that lifestyle. He is an artist. This is person, father, and son.
I'm going to take a few minutes, Mr. Geary and Mr. Steele, Mr. Adams, Mr. Smith, Ms. Rosenwasser. Just give me a few minutes. I'll come back out in a minute, okay? All right. We're going to be in recess.
Man, they finna do another recess, y'all. This shit crazy. Ooh. Vaughn here, man. I ain't gonna lie, bro. This shit get real, dog. It's real in the field. I guess we might as well just wait till the decision come back, bro. Fuck it. I'm gonna cut the volume down. I'm gonna just cut the volume down, man. I'm trying to do like 3-4 things at one time. I'm trying to drop this, do that. Crazy. Damn, bro. What y'all think, man? I cut it down. They on recess. They finna come make the decision if they gonna deny Young Thug a bond. So we just waiting to see. They on recess to see if they gonna actually deny him a bond or grant him a bond. So they will be right back, man. They will be right back. We gonna see. Anybody want to join in while we waiting to see? Anybody want to join in? So, hey, man, it's a tough situation, bro. We ain't never saw no shit like this in rap. I'ma always say, man, innocent till proven guilty. Every time I speak. All that, man. Yeah, man. We gotta wait and see, dog. I don't know for sure. I saw that somewhere, Rondre Daniels. Can anybody confirm that Gunna was denied? Can anybody confirm that Gunna was denied? Thug's lawyer is pleading a very, very heavy case. Why would the DA go after YSL before Trump? She going to have her shit together to go against Trump. But she is going after Trump too. To make it very clear, she is going after Trump. Okay, he is denied. Okay. They saying Gunna denied. I haven't actually seen it. I hope I can take your word for it. No disrespect, but I got to put allegedly on there, Elizabeth. Because people be saying shit on YouTube and then they be lying. I try to do my best to keep everything factual, man. So as of right now, they saying Gunna is denied. We are now waiting on Young Thug. They took the recess and we shall see. Yes, Gunna is denied until she says she a legal advocate. Okay, we'll take your word for it. We'll take your word for it. We'll take your word for it, legal advocate. Gotta wait and see, man. I ain't gonna lie, they like the DA is pressing everything that he's saying, basically saying, hey, bro, these are things that we can speak on in trial. This shouldn't have nothing to be spoke on with the bond. That's what the prosecutor is saying, like, hey, you going through and you speaking on the evidence that we using and you basically combating the evidence, which you supposed to do. The judge made it seem just, hey, bro, you posted, like he told the lawyer, Thug and them lawyer, like, nah, man, say what you feel. Like, you know, You know, we know the courtrooms are gonna be tense. We know we're gonna have issues, but we gotta wait and see, man. I'm just gonna tell y'all like this right here, bro. This they back is against the wall, bro. I always believe in innocent until proven guilty. Even the judge said that today. But right now, they are fighting for their lives. You know what I'm saying? They are fighting for their lives, bro. I know some people think this is a game. This shit is real life, nigga. Like, it's all, we seeing it on the screen, so we take these things as entertainment. We take these things as just fun and games, bro. But now, nigga, this shit real, dog. Yeah. This how the game go. Oh yeah, this is very far from a joke. This shit is real life motherfucking serious, bro. Real life serious, man. So what we can do right now is, bro, y'all can just wait for the recess. I gotta take care of something. I'm gonna be looking at the screen, but I gotta take care of some business real quick. We're gonna wait on the recess. I'll let it play. But I need to take care of something real quick, probably about a few minutes. So if y'all want to wait, y'all can wait. I'll probably go back live later on tonight just to talk about all this stuff. I'll probably go back live later on tonight to talk about all of this. So this is on 11 Alive YouTube channel. Yup. Yeah, y'all, I know y'all got to go do y'all thing, go do what y'all do, but this is on 11 Alive YouTube channel to go all the way back to the beginning if you want to do that. But I need to take care of something too. Take a quick break. Y'all take y'all a recess, but once they come back on, they come back on. I'm gonna have an audio on for them, so y'all can actually hear and see that. So there y'all go. Take me a recess. We gonna be back when they come back, and we'll get the news. Is Young Thug denied bond? We shall see. They on recess right now. If anybody coming in, they gonna come back with the decision on Thug in just a second, man. Just a second. Still here, y'all. Take care of something real quick. They on recess. We on recess. Party Mo, what's good? What's good? Party Mo, I see you. They're on recess right now. Y'all. Once it comes back in, that's Young Thug up in that top right-hand corner. We'll bring it back. They actually in recess in this case. We will see live. Will Young Thug be denied bond? This is on 11 Alive YouTube channel. They following this case heavy in the courtroom. Go subscribe to that channel to catch everything updated with the case and all that. innocent until proven guilty, like I always say though, man. Innocent until proven guilty. We in recess right now. It's on 11 Alive YouTube channel. Waiting to see what's gonna happen with it. They waiting right now. They just in a recess. So once they come back, we'll know if they gonna actually when they come back, we'll know if they're gonna do it guilty. I mean not guilty, I'm sure. This is the bond hearing. To see if Young Thug is gonna get bond. This is for Young Thug bond. Young Thug is in the top right hand corner of their screen right there, sitting in there waiting.
Yes, you do that, how do you? I mean, there are so many. It's just our that's how we talk. Oh, it was the one box that was the basically.
This should be a process, don't it? It should be a real process, don't it? back? Hold on. Okay, they still at recess. They still at recess. This how I go though when you in court for real. So for people that's just coming in, they took a recess right now. It's on 11 Alive YouTube channel. I'm at a link in the description after this video. But y'all could go on there. They're gonna have it broke down in clips also on 11 Alive. But this is exactly how it goes, man. It's a process. Young Thug's still sitting in there waiting this whole time. Think about this. Everybody else got to get up, walk out, go use the bathroom, take a drink, relax, stretch out. That nigga still sitting in there handcuffed, bro. He might not be handcuffed in that hole, but he still got to sit inside that little room and just waiting to see how this shit gonna go out. That Young Thug is right there, nigga. This a multi-million-dollar nigga right here, bro. One of the top rappers in the motherfucking game, bro, sitting inside this little room right now. This is how crazy this shit is, bro. But we waiting on the judge to come back. They on recess. As soon as they come back from recess, they'll let us know what the judge gonna let us know his decision on Young Thug's bail. They're making a great case that he not gonna go nowhere. He got family here, he got kids here, and everything like that. Of course, the DA is gonna say he's a danger to. I mean, the prosecutor, not the DA. The prosecutor gonna say he's dangerous to society, and he has the means to flee out and leave and affect the case in the free world. So we shall see, man. That's what's going on right now. Waiting on the recess to come. Young Thug right up there in the right, man. So we'll see. We waiting on it for sure. Sounds For everybody coming in, we at a recess, man. We at a recess right now, waiting on the judge to get back from the recess, and they gonna make their decision. Should be coming up shortly. Yeah, man. Waiting to see. It's a process. That's how I really go though on the cool. No lie. This how this stuff really go. If y'all thought it was a game, it is not. It's never a game. Shit. Hold on, we about to get started. Should be getting ready to get started. It's coming back.
Please see everyone. Christina.
Finna see y'all how it goes. We back. He's gonna make his decision if he's gonna deny the bond right now.
All right, I've had an opportunity to reconsider the defense's additional pleadings that were filed in this particular case on motion to reconsider bond. It's filed on behalf of Mr. Williams. I have considered those arguments under the new indictment of 22 SC 13572, even though they were filed under indictment 20 USC 182273. And I consider the proffers made by state, I consider the arguments of the defense. At this point in time, though, Mr. Adams and Mr. Steele, I am still not convinced that that what you've argued, or what you've continued, or what you've argued, anew and taking into account what I have heard already, I still believe that the court is the court's decision that the four factors under consideration, that I'm going to deny bond at this point in time. It is not lost on me that your client's in custody. Not lost on me your client enjoys a presumption of innocence. I respect all of you as seasoned advocates. And I understand fully that there are differences in bond and differences in what may be pled at trial. And I understand that you all as defendants don't have any responsibility at all to present anything, that the government has the responsibility to present and prove everything that's alleged in the indictment and the elements therein to a satisfaction of beyond a reasonable doubt. So that will be decided later, but at this point in time, under Title 17 and under the case law that's been argued thus far, I'm not going to grant bond at this point in time. But I'm staying denied. Is there anything else I need to kind of go through with you all at this point in time? Mr. Adams or Mr. Steele, we have proffers. The remaining proffers, I will attempt to try and get those folks here for the 8th of September, who are otherwise unrepresented or maybe in the Department of Corrections. Anything else? And I understand you all have some motions you're about to file. If you should, for whatever you file, please send courtesy copies to myself and in particular Mr. Kearns and Mr. Chamberlain, so that because we're not an e-file party, the court is not an e-file party, and that's the only way we'll get those. And upon getting those, I will figure out a date and schedule you all for any motions that may need to be heard or issues that I need to take up. Okay. All right. Mr. Geary, anything? Okay, we have dates, and Mr. Geary, you owe me, I believe that you have presented orders. I have signed those. Mr. Chamberlain should have given those back to you. You will file those, e-file those for the null process in the case. Yes, sir. Just want to make sure I have the right. Under the old indictment, that would have been 22 SC 182273, and the motions that have been filed on that will be carried over into the new indictment ending in 572. So I'll need that, and we have several matters that will need to be taken up on the 8th of September. Mr. Chamberlain will go ahead and publish or send out notices for that. Mr. Chamberlain, anything else, sir? Yes.
I've been here all day, so I have not got a chance to confirm, but I can send them for all the individuals that I know that are unrepresented in DOC custody. That's nothing.
Particular custodial information, yeah. And what I will do, Ms. Rosenwasser, if you would go ahead and I know that you all have told me which individuals are not represented, but if you will roll that up, and I think you may have done that while we're sitting here. I'll go ahead and I will go ahead and include all of you on an email. I did receive an email from bear with me. Please bear with me. Ms. Vanessa Carroll. She's an attorney with the Southern Center for Human Rights. We were very interested in this lack of C3 representation. So I will go ahead and send out another email to Ms. Bernard and the folks and Ms. Ali, and send out something to see if we can get some movement with that. And if it goes much further, I'll have to relook the situation. I may have to ask the county for some funds to appoint counsel to represent folks who are unrepresented. But I'm not going to let it go much longer. So that's still on my radar. All right, anything else? Okay, then, everyone, I appreciate your patience. Mr. Adams, I apologize to you again if you've had, for any slight.
That's how it go. Young Thug was just denied bond, man.
Know
So
that all of you are held in high esteem, in the criminal
we'll talk real quick.
justice system in terms of your advocacy and
Before we
abilities to
end
advocate.
this, we'll
Okay.
talk for a second.
Okay, all right. And Doc, we're in recess, all right? Okay.
Oh, they having another recess? All right, I'm gonna end it after this right here. We'll finish with all this stuff. See if they're gonna put the camera back on Thug, but the bond has been denied. Okay, I'm gonna go ahead and get off it. They're gonna have more stuff going on in court today, though. But him and Gunna appeared on the same screen today. This was a crazy situation, bro, throughout the day. This 11 Alive YouTube channel, though, so y'all go tap in with them if y'all want to get more stuff on it and all that. Long motherfucking day, bro. Long motherfucking day. Like I told y'all, man, it's a part of it. Innocent till proven guilty. There's other things that's going on in this case I'll tap back in on later as to where we at and all that. That's my bad. I'll tap back in later. I'll tap back in later to like speak on everything, man, and give y'all updates on the information that is public, that has been put out there. So if I don't have to go and do nothing tonight, I'll tap back in on all that stuff later, man. They got real classified stuff going on with it. This is part of the game, bro. You know what I'm saying? Innocent until proven guilty, but they all have been denied bond again. They got some people that's in prison already for other things. They part of the indictment too. So, you know, or one guy is that they had on there today in court also. So we'll keep y'all updated on everything, man. And streets is real, bro. And this is a part of the streets. I'm not saying they guilty, innocent until proven guilty, but these things, this is the process. This is how these things really happen, though. So just know this is it. We shall see. Hey, this is the game. Shout out to 4G Forever. Shout out to everybody in the chat. We'll see what happens with everything. I'm probably go live later on tonight. We'll tap in on it some more, man. So 1,000, stay on your period for shit show. Got more coming.